Now turn to the second case on this morning's docket. That is case number 105384, State of Kansas v. Anderson, Cheffen.
It appears to the counsel, Michelle Davis. Mr. Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted, and before we start this case, I wanted to announce that I'll be stepping down from the bench in about 10 or 15 minutes. It's not meant to be a negative reflection on anybody's arguments, and I'll be gone the remainder of the morning. All right. Please proceed.
What I wanted to do was to discuss the first issue in the brief and then submit the other two issues on the brief. And the first issue in the brief is another question of statutory interpretation, which is a question of law over which this court has unlimited review. And it's that the statute is KSA 22-3421. And the issue is that the district court's procedure in handling the verdict did not comport with the plain language of that statute. What that statute requires is that the written verdict is signed by the presiding juror, and then it's read by the clerk to the jury, or in this case it was read by the bailiff to the jury, and then the court is to inquire as to whether it's the jury's verdict, and that's so that the jury can affirm in open court that that is its verdict. And then if no disagreement is expressed, then there's a second step to the process where either party can request that the jury be polled. And once those two steps have been satisfied, then the verdict is complete and the jury is discharged.
This issue wasn't raised in the district court, correct?
That's true.
Does that cause you a problem?
It's our contention in the brief that this court can address this issue based on case law that says when it's a question of law and the facts are not disputed, that this court can reach it. And then the second basis would be because it implicates a fundamental right.
What's the fundamental right?
In our brief, we said it was a fundamental right to a unanimous jury verdict.
And
And
are you, I can't remember who we had this discussion with, or was it you that we had the discussion? Well, obviously it was.
Yeah.
So you'd say the same things you did earlier in the week, that even though it's a statutory right, you still deem it to be fundamental.
And there is some case law on that from the Court of Appeals that says that jury unanimous, statutory right to a unanimous verdict is a fundamental right. And that's the case that we usually cite in our briefs. It's not cited in this particular brief. And then I think that this procedure, this statute, isn't just about a unanimous verdict, and there's some case law to support that. It's also just about your right to have a jury determination. So I think it is also a constitutional right. And there's some case law, it's State versus Johnson, and that case is in our brief as a Court of Appeals case that talks about that this is affirming that this is the jury as a collective is making this determination.
So what's the difference between asking the jury before the verdict's read, and which is what happened in this case, versus asking them after it's read? Because clearly that's a different factual scenario than forgetting to do it all together.
Yes, and I would refer this court to the Gray case, which is the Court of Appeals case, and in that case they said, at no point after having heard the verdict read in court were the jurors given an opportunity to express disagreement with the verdict. So that would be the whole point of the statute, isn't once the verdict is read in court that the jury is then asked, is this your verdict? So in this case, when the jury came in and they handed the verdict to the bailiff, and let me make sure I get this right, the court asked, have you reached a verdict? And the presiding juror says yes. And the court says, so say you all. And the jury says yes. And then the bailiff announced the verdict. And then the court did not go back to the jury and say, is this your verdict? So that's the difference, is that the procedure, the jury's supposed to affirm.
I understand the factual difference, but what's the substantive difference?
Well,
really, so what?
Assuming that there wasn't an error. When they talk about that in the Johnson case, it's a safeguard to prevent error or misunderstanding. So you're assuming that the presiding juror, when he wrote that this was the verdict, you're sort of presuming that all got reported correctly. And that when the judge asked the jury, so say you all, that the jury, whatever the jury's thinking at that point of what the presiding juror wrote is what their actual verdict is. That would be the difference. That there wasn't any sort of error or misunderstanding, and that the jury is affirming again in open court. And then the only other thing that I would want to point out is that Well, in this case, the judge did not specifically ask the attorneys if they wanted to have the jury polled. The judge just said, are there any motions? So there wasn't any separate inquiry made, which there is some case law, Dunlap from the Court of Appeals, that says, polling can sometimes cure this problem. But in this case, there wasn't any polling.
Isn't this a prime example of the reason for the contemporaneous objection rule in the first place? If an objection had been interposed, it could have been fixed right then, and your client would have gotten his rights, and everything would have been taken care of. Mm-hmm. And instead, by raising it for the first time on appeal, we jeopardize the whole trial and all of that. So why shouldn't we hold you to the contemporaneous objection rule in this case?
Well, because by statute, the only statutes that say that are the evidentiary statute that says that if you don't object to evidence that's presented.
But we have the rule about raising an issue for the first time on appeal that goes beyond 6404, don't we?
Mm-hmm. Yes.
And this is a prime example of why we have that, isn't it? Is that it could have been fixed easily by just simply pointing out to the judge, hey, you need to advise or make inquiry after the verdict's read.
But you also have the 6261 that says that any error in the court's proceedings, and it talks about it affects substantial rights. I mean, that statute really more covers this sort of situation, I think, more so than the contemporaneous objection rule. There's an error or defect in the district court's proceedings. It sort of sets forth when this court is supposed to review that. So I think that's what obviously I would concede your point, Justice Johnson, that it would have been preferable to address this with the district court, but unfortunately that doesn't happen all the time. And moving to 60, I just did want to mention 6261 just briefly because the Court of Appeals in Johnson and also in Gray, they said this was a reversible error. And the district court in Gray said it was a reversible error because of the importance of the requirements of unanimity and finality with respect to jury verdicts. And then the court in Johnson said it was a reversible error because the verdict was not complete until it was affirmed by the jury in open court. The verdict's not complete. And so I think this goes beyond just the recent harmless error standard that you've said, which is more goes to the outcome of the proceedings, that if there's a reasonable probability that it didn't affect the outcome, because I don't think this sort of situation falls within that sort of standard. I think this has to more look literally at the language in the statute, which talks about affecting substantial rights, and more about the procedure than it is about the result. That would conclude my comments.
You've cited to us a lot of Court of Appeals opinions. Do you have an opinion from this court that you could rely upon?
No, I don't, Justice Nuss. I know there's a case that you authored that talks about polling and the procedure around polling, but I didn't see one that went to the court's duty to inquire of the jury as to whether it's the jury's verdict.
Any further presentation, counsel? Any questions of counsel? Thank you.
May it please the Court, Cheryl Lidke, Chief Deputy District Attorney, Wyandotte County, on behalf of the state. The difference between this and Johnson is that there was an inquiry made into whether this jury's verdict was unanimous. Judge Burdett clearly said, "So say you all," which is the equivalent to, "Is this your verdict, entire jury?" And which the Court of Appeals in Gray said that was appropriate, that satisfied that part of 223421 that says an inquiry needs to be made whether it's the jury's verdict. We brought up in our brief that it really was irrelevant whether or not he asked that question before it was read in open court or not. The statute itself does not require, it doesn't say the order in which
But
these things have to occur.
how's that a confirmation?
Because it's been written and signed and handed over to the
But
bailiff.
it's not signed, it's only signed by the foreman
Correct.
or foreperson.
Correct.
And that foreperson is the one that's going to announce it. But what if one of the other jurors is confused about what the verdict was?
Well, it's been written and signed and turned over as the verdict of the jury. And so when the judge says to them, "So say you all," in other words, in what's in this paper, is this what all of you agree to? And they say yes, then we don't see the difference between reading it out loud then and saying, "Is this what you all agree to?" It's the same thing. And because the statute doesn't require that it be read or done in a certain order.
No, it requires that there be confirmation of the verdict.
Correct.
Right.
And I think that's what Judge Burdett did. To me, this is fairly simple. I don't see that there was any question at all about jury unanimity, especially when, after the jury's verdict was read, the judge turned to the defendant, "Okay, so now do you have any motions?" And he said no. And so clearly he gave him an opportunity. If there was any question in his mind at all at that time about unanimity, he could have asked that the jury be polled.
And I just want to be clear at what you said, and I think you argued this in your brief, if I remember, but you don't think 3421 tells us the sequencing
Correct.
of the actions.
I don't. All it says is that it needs to be written, signed, and read. Inquiry needs to be made as to whether it's the jury's verdict. It doesn't say which one of those things need to be done first. That is the order in which it's listed in the statute.
And it's all one sentence.
Right.
It sort of said this is how it's supposed to go. And there is a common, and you have to concede there's a common sense argument in
Sure.
what Ms. Davis says, because if there were a mistake on the ballot, then it would require a juror to affirmatively stand up and do something saying, "Oh no, wait a minute, that wasn't my verdict." Where if you read it and then you say, "So say you all," then you've got it more confirmed on the record.
Right. But I think you have to look at it overall, too. They've been instructed that they have to be unanimous in their verdict. And we presume that jurors follow those instructions. So they've been told that. They go back to deliberate. They come back out and they turn over a paper that they've been told has to be signed by a presiding juror to reflect their collective verdict. You've got a judge asking them, "So say you all," and they all agree.
And then the verdict comes back and it's guilty, and they all thought that it was innocent. We would assume somebody'd say something.
Well, and I think that's why the additional protection is there, that if the defendant believed that there was some sort of disagreement, since that maybe one of them showed some emotion when the verdict was read, he had the opportunity to ask for the jury to be individually polled, and he didn't do that. I'm going to submit the second issue on the brief because I argued a similar issue on Monday. I think the court is well aware of what the issues are on whether felony murder is an alternative means offense. But I did want to touch briefly on the third issue regarding whether or not there should have been a lesser included instruction for second-degree intentional murder. I just wanted to argue that there was no evidence of an intentional killing in this case at all. We never alleged that. All we know for sure is that there was child abuse that was committed and that this child died as a result of that. And so I think the defendant is confusing his intent to abuse the child, his intent to inflict harm upon this child with intent to kill.
Well, I have a question. You're probably aware of this is a common issue in felony murder and premeditation cases, is what are lessers and what aren't. What about second-degree reckless? Wouldn't that be a potential lesser based upon the evidence in the case? What about voluntary manslaughter? There's holes in the wall. It could have been a fit of rage and anger and fist hit the wall and did something.
Well, I don't think it could have been.
Where's the line drawn on these things?
I think you have to draw the line by the facts that come out in each case.
Exactly.
In this particular case, the act that was inflicted upon the child was not reckless. There was no evidence that it was an accidental throwing of the child into the wall.
So it's intentional.
So that act in itself was intentional, but that's way different than saying that he had an intent to kill. We'd have to get inside of his head and have some sort of evidence of what he was thinking when he did that, and there just was no evidence about that.
We can infer that, though, and then when you start thinking about the nature of the injuries, the force of the injuries, I think it was your argument in court that he drove by hospitals in order to go, or one hospital in order to go pick up the mom before they went. Mm-hmm. I can see you on a different day arguing inferences from that.
Yeah, I think
that would go to intent to kill.
There are some cases where the circumstances, the nature of the injuries themselves, the acts taken by the defendant, you could infer that he had an intent to kill. But I don't think this is one of those cases. In this particular case, all we know for sure is that that child was swung into the wall one time. We know from the younger child that was inside the home that there was some sort of crying going on beforehand, and then he was trying to pour water on the child's head afterwards. So it was all left to speculation as to whether or not that one throw into the wall was an intent to kill, or was it certainly an intent to injure this child, to abuse this child. Things got out of hand, and he didn't intend to kill the child, but the child did die as a result of it. I just don't think this is one of those cases where, like if you're stabbing somebody or if you're shooting somebody, you can say for sure what their intent was just by the nature of the weapon they're using or how they're using it. The fact that he's flinging this child up against a wall, I don't think that is the type of a factual scenario where we could draw that connection to intent to kill. But I agree with you that there are probably some cases where you could. So, I really don't have anything else to say. I'll rest on my brief on the other issues unless there are more questions.
Thank you, counsel.
I am prepared to waive rebuttal.
Are there any questions, Ms. Davis? Thank you, counsel. Thank you, counsel. The court will take this case under advisement, and the court will be in recess for 15 minutes.